Richard Padilla will be presenting a very brief staff report on this item. Thank you.
Yes, good evening, Mayor, members of the City Council, members of the audience. Of course, we are here today to discuss some options that would be available to the city in response to perceived Brown Act violations, which I think are detailed a little more specifically in the staff report that accompanied the agenda. Basically, there are two operative statutes which offer remedy to the city. The first being Government Code Section 54963, dealing specifically with violations of the confidentiality requirements of the same section. The remedies available to the city in the event of such violations are pursuing injunctive relief. That's sort of a civil action that the city would pursue to enjoin a particular person from engaging in conduct that is deemed violative of the Brown Act. Another option, though, would be to refer the matter to the civil grand jury. The civil grand jury is a body of the county of Los Angeles. They are tasked with, among other things, doing inquiries on potential violations of state law, including the Brown Act. That's also an option available under 54963. More generally, under Government Code Section 54960, that is the provision that allows any interested party, including the district attorney, to pursue either mandamus, injunction, other appropriate relief for alleged violations of the Brown Act. So our third option would obviously be to also refer the matter to the district attorney for potential action. So that is what's before you tonight. I don't know if you have any questions. I certainly don't want to belabor anything at this point, but if you have any questions, I'm happy to answer.
Beginning with Councilmember Soto. Mr. Mayor, I'll defer until after my colleagues speak, and you're including yourself. Councilmember Gonzalez.
Well, obviously it's a tough situation, but I think if there was a clear violation or even a violation of the Brown Act, what it seems to be, I believe part of our duty is to send it and get it out of our hands. It's not our job to do that. I think we would have to send it to the grand juror or to the district attorney to have them actually go through it and see what, declare if there was a violation or not. And I think that that's what we should do. And then as far as seeking an injunction, and can we go over that a little bit more, just so we're clear on that with everybody?
Yes, civil injunction would require the city to sort of step in the role of, I hesitate to use the word prosecutor because we're not necessarily prosecuting anything, but what we would be appealing to the court to do is to issue an order which would enjoin a specific person from engaging in certain violative conduct. That's probably a remedy that we would have the most control over if we were to pursue that. Referring it to the grand jury, the DA obviously leaves it in their hands, and it's up to their timetable as to how quickly they want to pursue it or whether they even think there's anything there to pursue. With respect to the injunction, what would be sought presumably is an order that identifies certain prohibited conduct and that appeals to the court to issue an order, basically a court directive that tells the person who is the subject of the injunction to refrain from certain activity. If that person violates the court's order, that person becomes answerable to the court, because the court has broad authority to sanction someone for a violation of what I think the court, particularly with respect to issues that relate to participation on a legislative body like this one, the court certainly would probably want to escalate enforcement. They probably wouldn't want to go to the nuclear option right away, but that's certainly within the court's arsenal to pursue. So I hope that answers your question. Fairly straightforward.
Thank you. So my recommendation is I think we should take items A, B, and C into consideration due to the fact of the evidence that we have been given violations of the Brown Act, and also what did happen in our closed session agreements and what was discussed and how councilmen completely went against what was said as far as illegally recording closed sessions. We told him not to, we suggested that our voices not be added and continue to. So I think we should definitely send it off and just out of our hands, and whatever happens with the DA or the grand juror, just leave it in their hands to see how they deal with it.
Councilmember Lopez?
Thank you, Mayor. I'll echo similar thoughts that Councilmember Gonzalez noted there. To us, or to me myself, there's a clear Brown Act violation when the tape recorder was brought into closed session. I think we've had the discussion in the past. I think Mayor actually was in favor of kind of recording our sessions back since I don't know how many years ago, and then it was brought up again when we were
Provided that we all agree.
Yeah, exactly, that everybody agreed.
The majority agreed.
But no, not the majority did not agree to that specific item. So therefore made it clear, and I think Soto was in this conversation during that time as well. So it was clear to everybody who was that we should not be recording our closed session items. And I was surprised when I arrived in the room and I saw a recording device there. Being that I'm one of the most vocal on that item, that I think having a closed session is serves reason for, at least for this body. To not sure what Soto, Councilmember Soto will say, but I think it's very clear. I'm not sure if he's taking our class that we're all required to take class. I think it's available for all of us since day one as we become council members as well. It's online, so there's no excuse that he should not know how we conduct ourselves up at the dais and at closed session. So I think similar to what Councilmember Gonzalez stated is it's something that needs to go away from the city council. Someone else has to make the decision. We have to present the facts to if it's the civil grand jury or the DA. So at this point, that's all I have to say.
Vice Mayor Bellin.
Very clearly, Councilmember Soto took everything out of our hands, and we have but no choice to recommend all of the above. Every action that you, or option you presented, we have to move forward with it. And he's the one that put us in this position to have this discussion here today. We wanted to have it in closed session. We attempted to have it in closed session. And even though we asked to repeat it, you were very clear. And I said I do not appreciate that recorder being on. He continued to record. I don't understand why somebody would say, I'm recording, when he's been told not to record, and that is the policy not to record, but he just was very blatant and disrespectful and said, I'm recording. And not only that, we haven't even touched on the fact that he copied SEIU representative on closed session discussion, which I would think it's almost unheard of that someone would do that. So I'm not clear if Councilmember Soto is representing the residents or representing the SEIU Public Works Group. I know that the residents elected him to sit here and represent them, but I think pretty much since he's been on City Council, he has really not represented the residents. So my recommendation is to go with all of the above, and whatever the decisions are from the decision makers above, we just abide by that.
Thank you. I had the opportunity to speak to Mr. Olivares about this earlier, and then after the meeting with Mr. Padilla, and it gave me some insight into this. I held a similar position to my council members until I received more information, and I suppose that there are two components to this. The first component is with regards to the injunction with the closed sessions. I think the ultimate goal would be, or the filing would be, to preclude Councilmember Soto from joining those closed sessions. Is that correct?
That could be what's pursued. I mean, I'm only explaining this for purposes of foundation and instruction. There's two issues here. One was the issue of a perceived leak of closed session information from a prior city council meeting. The second apparent perceived violation is recording basically engaging a recording device during a subsequent attempt at having a discussion about the first alleged violation. Yes, one potential option that could be sought would be to enjoin the councilman from participating in those meetings that specifically relate to that.
That's fine. And when I asked both you and Mr. Olivar separately what the likelihood of that happening, both of you told me it was exceptionally unlikely. And I think that you used the term that they tend to use more of a scalpel than a hatchet. Is that correct?
Yes, if I may, I think it is unlikely that a court from the outset would bar a councilman from participating in closed session altogether. But what the court would more than likely do, assuming it agreed that there was a violation and agreed that there's an ongoing problem, would more than likely just issue a directive saying, thou shalt not leak closed session information and thou shalt not engage a reporter. If that were to be violated subsequent to that, I don't think it's out of the question that the court might then say, okay, I've given you one chance and now that's been abused and now I will bar you from the meeting. But I see it more as probably, it's more likely that the court would escalate to that rather than jump to that from the outside.
Let's say that you got, or before that court date, Mr. or Councilmember Soto already handed you a statement signed to the City Council as well, stating that he recognized that it was a mistake and that he is advising us that he will no longer bring recording device to closed session. Would the court still rule, or would they just dismiss based off that?
I think that would be certainly welcome, and I think that certainly should be something encouraged if that was something the councilman were inclined to do. I think if that were the case, filing an injunction would probably be premature at that point. I think perhaps we would want to see if the councilman were true to his word as stated on the written document. That would certainly be persuasive for us. If subsequent to that he would violate that, I mean, obviously then it would demonstrate an acknowledgement that that's not appropriate conduct and then violate that appropriate conduct subsequent to that. But I would certainly welcome that if that were to be the case.
And I think Mr. Olivar has opined something similar earlier. And just so the council is aware, I haven't had any conversations with Mr. Soto about this, and for all I know, he might laugh at the notion when he chooses or when he speaks next. So we could actually have the same effect here in the council than if we were to go to court and spend money on litigation or legal services, correct?
Well, I don't want to give them this impression that the statement itself would have any sort of the same weight and force and effect as a judge's order, but obviously it certainly helps. It's persuasive.
Okay. And Mr. Olivares, you gave me your thoughts earlier on the second item, which is the referral to the, I believe, to the district attorney or to the grand jury. And what is your experience on how they normally handle these types of matters?
Mr. Mayor, members of the council, we have in the past referred these types of cases to the district attorney's office. Once we do submit it to the district attorney, it's out of the city's hands, and it's completely up to the discretion of the district attorney as to whether or not they're going to do something with it. So once we give it over, we'll probably not even be notified if they do decide to do anything. It's just completely out of our hands.
And what is your recommendation for the outcome of this? I know that you're not a decider, and sometimes you hesitate to give recommendations on what you feel might be political issues. But what is your recommendation, or what do you see as the best solution to this?
Well, I would hope that all members of the City Council abide by the Brown Act. So my hope would be that we can get to a point where everybody makes sure that when we discuss things in closed session, things don't get leaked, that we abide by the rules that we have here in the city and in the state. But as far as what to do in this particular case, I don't have a recommendation. These are the options before the City Council, and it's up to the City Council as to what they want to do.
I do agree with the notion that it does appear that there was a Brown Act violation, and we can have a grand jury tell us that, or we can have the DA, but I think that it would be redundant to what we already know. I also agree that a reprimand or a censure at the very least is in place, given that this is a type of action that cannot happen again, whether it is the disclosure to the SEIU or whether it is the recordings in the closed session. My recommendation would be that, well, first I'd like to hear what Councilmember Soto has to say. There's no way to know. But my recommendation would be that we censure Councilmember Soto for his actions. And if he agrees to take his class in 2 weeks, which he should have taken before, which outlines these rules. And if he agrees to provide a written statement indicating that he will not record any other closed sessions, and that we handle the matter within the council, it'll be done more expediently, it'll be done more efficiently, and we can move on with more important business. If he doesn't take those prescribed actions, my recommendation is that we do move forward with the options here. Councilmember Soto?
Thank you, Mr. Mayor. Yeah, we did speak with Mr. Olivares a little bit earlier today, but just for the record, Madam Clerk, I would like to just state the following. If there was a Brown Act violation, it certainly was not intentional on my part. I'm a very transparent person and did not realize that there are boundaries in transparency. If there was a violation and anyone was offended, I would like to offer my apologies. As a new council person, I have not completed my Brown Act training yet, but I am stated to attend sometime in the coming month of October of 2015. Thank you.
I have a question. Would you be willing to provide a written statement saying that you will no longer bring a recording device to council?
I have no comment on that, Mr. Mayor. I will say something, Mr. Mayor, is that I want to say to Mr. Olivares that I do appreciate the city reminding me periodically about the Brown Act training. And, you know, as someone who's not a politician like myself, I'm really consider myself a public elected official. I know there is a deadline. I know that we have a year. And if I may suggest to our city attorney and the council that this may be a good time to take upon the issue of maybe making the Brown Act training a mandatory requirement as soon as assuming office instead of the duration of the 12 months for these reasons and or others that may fall. That is all I have, Mr. Mayor, to answer your question.
Are there any other points of discussion amongst the council? Vice Mayor?
I have to say I'm very disappointed in the mayor's recommendation. I have no choice but to say that. It's unbelievable to me that the mayor would even make that recommendation. It was very blatant. Why are we here today? Why is this on the agenda? We should have had this discussion in closed session. But here we are today, and I'm speechless. I'm absolutely speechless, and I'm just going to move that we move forward with every item that's recommended.
Vice Mayor?
And I'll second that motion.
Vice Mayor, then in response to your comments, my comments are directed in a way so that we can resolve this quickly, so that we can have the same effect, and so we can move on to city business. Unfortunately, Councilmember Soto does not see the need to address these items in a manner that I believe is necessary for us to move on. And these are the options that we are limited to, given that. So with that said, there is a motion on the table, and there's a second. All right, roll call please, Ms. Chavez.
Councilmember.
One quick. Is Councilmember Soto able to vote on this, even though it concerns him?
Yeah, Mr. Mayor, members of the council, I've recommended that I talked to Councilmember Soto previous to the meeting, and I recommend that he not vote on this item.
Okay. And you're aware of that? Are you choosing to vote on this, Councilmember?
For the record, Madam Clerk, I refrain myself from this.
You may proceed.
Councilmember Jaime Soto refrained from this vote. Councilmember Antonio Lopez.
Yes.
Councilmember Robert C. Gonzalez.
Yes.
Vice Mayor Sylvia Ballin.
Yes.
Mayor Joe Fajardo.
Yes. The motion carries.
Madam City Clerk, can you just let the record reflect that he abstained, not refrained from the vote? Thank you.